Hi, I'm attorney Kelly Longtin, and I want to thank you for watching and subscribing to our YouTube channel. Today, I want to talk to you about your retirement accounts and what happens if you want to leave them to your minor child, and just some things that you should consider before you do that. Now, your retirement account might be one of your most valuable assets that you have, and many people consider naming their children as beneficiaries of these accounts because they think it's a way of easily transferring their wealth if something happens to them. However, there are some factors that make this type of transfer a little bit more complicated than you might think, especially if your child is a minor. Let's talk first about whether or not a minor can be named individually as a beneficiary. You definitely can name your minor child as the beneficiary of your retirement account or as the contingent beneficiary who would receive it if that primary beneficiary that you listed on the account had passed away before you. However, if your child is a minor when you die and they inherit your retirement account, a court may have to appoint a guardian or a conservator to watch over those monies and to handle it for your minor beneficiary. Of course, that's going to take time and money, and the guardian or the conservator, whoever the court has chosen for this role, may not be the person that you would have chosen. And you can avoid this by proactively naming a conservator or a guardian for your minor child in your will. Under the Setting Every Community Up for Retirement Enhancement, the SECURE Act, most beneficiaries must receive an entire retirement account within 10 years of the account owner's death. However, minor children of an account owner fall into a special category of beneficiaries, and they're called Eligible Designated Beneficiaries, or EDBs. Their mandatory 10-year payout period does not begin until they turn 21, meaning the beneficiaries must receive an entire inherited retirement account at age 31. In the meantime, however, they are required to take required minimum distributions, or RMDs, which will likely be held in a protected account that's overseen by their guardian or conservator until they reach the age of majority in the state where they live in. Usually that's between the ages of 18 and 21, again, depending on state law. Now, RMDs for these beneficiaries, they're based upon the child's expected lifetime, and they must take them at the end of the calendar year that they turn 31, at which time the retirement account must be fully distributed. Now, it's important to note that the child will have to pay income taxes on any amounts distributed to them. This is usually favorable because the RMDs, up until the year they turn 31, can be made in smaller amounts because of the long life expectancy of a minor and because they will likely be in a lower tax bracket. However, the account must be emptied by the end of the calendar year in which the child turns 31. Now, depending upon the size of the account, this could mean that the child will receive a large amount of taxable income at a relatively young age. In addition to the potential tax liability, one of the disadvantages of naming a minor child as a beneficiary of your account is that when they reach the age of majority, which could be as young as 18 in your state, they will gain complete control of the funds and could choose to pull everything out of that retirement account right away, regardless of whether they were mature enough to handle that responsibility at that point in time. So a question that gets asked all the time is whether you should name the trust as a beneficiary of the retirement account and your child as the beneficiary of the trust. Another option for all of you is to create a trust for your child and to name the trust as the beneficiary of your retirement account. This option can work for what we call see-through trusts that meet certain criteria under the law and allow the applicable beneficiaries of the trust to be treated as the beneficiary of your retirement account. Now, there's two types of see-through trusts that are usually considered. They're called a conduit trust and an accumulation trust. Now, a conduit trust requires all required minimum distributions made from the retirement account to the trust to be distributed to the child or used for the child's benefit as soon as the trust receives it. The trust will provide asset protection and tax deferral for the funds that remain in the actual retirement account. In addition, the terms of the trust can ensure that once the child reaches the age of majority in your estate, that they will not be able to simply withdraw the entire balance remaining in the retirement account all at once. The trustee can also have discretion to withdraw funds from the retirement account in addition to the required minimum distributions, which would then be distributed to or for the benefit of the child. But these decisions about additional withdrawals will be made by the trustee rather than the child. Although the remaining balance must still be fully distributed to the child by the end of the calendar year in which the child turns 31, until that time, the conduit trust will provide asset protection, tax deferral, and additional time for your child to mature and learn how to handle the money responsibly before receiving a potentially large sum of money. The other type of trust is what we call an accumulation trust. And an accumulation trust, unlike a conduit trust, provides the trustee with the discretion to decide whether to pay out the RMDs to the child or for the child's benefit from the retirement account or to retain the funds in the trust. As a result, the full amount of the funds distributed from the retirement account to the trust can stay in the trust and can potentially be protected from claims made by outside creditors. An accumulation trust will enable you to ensure that the funds are not distributed to your child sooner than necessary or sooner than they're desired, and that the child does not gain access to the entire amount in your retirement account as young as the age of 18. However, the funds must still be fully withdrawn from the retirement account by the end of the calendar year in which your child turns 31. Any funds retained by the trust instead of distributed to your minor child will be taxed at the much higher tax rates applicable to the trust rather than the lower rate that is likely to be applicable to your child. Now, there are pros and cons for each option of trust that you choose, and the one that is the best fit for you and your child will depend on your unique circumstances and goals. So we help our clients think through whether asset protection or tax minimization or another goal is their priority or whether it should be. If you've already made your minor child a beneficiary of your retirement account or have set up a trust as the beneficiary of your retirement plan for the benefit of your children, then it is important for you to review and just update your beneficiary designations and your trust if need be. So there's some recent changes in the rules that govern these important accounts, and they may have a big impact on when those funds must be distributed and a big impact on your children. And it may necessitate a change in your overall estate plan. So I want to thank you for watching. If you are interested in learning more about estate planning, please like and subscribe to our page below and follow us on YouTube. We're also on Facebook, Instagram, LinkedIn, so you can always follow us there as well. Thank you for watching. I'm attorney Kelly Longtin from Kelly Longtin Law.